is Lawyers Committee for Better Housing. Welcome to tonight's episode of Tenant Thursdays. We're happy tonight to welcome our friends Maria Moon and Patricia Fraun from Chicago Area Fair Housing Alliance and Aileen Flanagan from Lawyers Committee for Better Housing. My name is Alan Haley. I'm the Director of Development and Communications at Lawyers Committee for Better Housing. And LCBH is a 40-year-old organization that provides free legal and supportive services for renters facing unjust evictions or living in substandard housing. If you are watching tonight and are a renter or know somebody who is facing an immediate housing crisis, please have them visit rentervention.com, or you can call us at 312-347-7600. Before we get started tonight, I would just like to ask each of our panelists to briefly introduce themselves and tell us the organization they're with and what their role is at that organization. So Aileen, if you wouldn't mind getting us started.
Great. Hi, good evening. My name is Aileen Flanagan. I'm a senior supervising attorney at the Lawyers Committee for Better Housing. I've been here for quite a few years, and I'm happy to participate in tonight's talk. We do advocacy for renters throughout the city of Chicago, and we're very happy to present this information and to welcome our subject matter experts in this area of law, Trish Fraun and Maria Moon. So I'll pass this on to Trish. Trish, can you please introduce yourself to our guests?
Hi, thank you so much, Aileen, and thank you both for having us tonight. My name is Patricia Fraun. I'm the co-executive director with the Chicago Area Fair Housing Alliance. We work to combat housing discrimination and also promote equitable place-based opportunity through education, advocacy, and collaborative action. We have a whole base of member organizations and individuals who are all working together, again, to combat housing discrimination and mitigate the harms caused by residential segregation. And I'll pass it over to Maria.
Thanks, Patricia. Thank you all for definitely inviting us to have this important talk about JHI. So I am Maria Moon, and I am the Housing Justice Organizer with Chicago Area Fair Housing Alliance. Not only that, I am a person who is directly impacted by housing barriers because I was incarcerated myself also. So thank you all so much.
Thank you again, Patricia and Maria and Aileen, for being part of tonight's Tenant Thursday. So before we get into the focus of our conversation regarding the fair housing rights of people with records in Cook County, Patricia, can you share with us what fair housing means more generally?
Sure, I'd be happy to. So really at its core, fair housing is a person's right to choose where to live and to enjoy full use of their homes. So everyone should have equal access to housing because housing is really your anchor that centers you to all other life opportunities. And that's healthy environments, educational opportunities, job opportunities, anything you can think of, your home is the centerpiece of that. And fair housing removes the barriers that restrict access to your choice of where to live. Fair housing protections in their essence are a set of laws at the federal, state, county, and sometimes city levels as well that protect a person's right to live where they choose and to enjoy the full use of their homes without discrimination, interference, coercion, threats, intimidation. And this could come from not only owners, landlords, and real estate agents, but also any other persons that interfere with that freedom of choice. And that could include, a neighbor or someone living next door to you. So the law provides protections against discrimination based on what's called your protected class. And the full range of protected classes can vary depending on where you live in the country, but everyone in the United States is protected from discrimination based on race, color, religion, gender, and that includes sexual harassment, national origin, and that's the country you or your ancestors came from, your disability status, and what's called your family status. And that means if you have children in the home or if you're expecting children through pregnancy or through adoption. So what this means in kind of the real world implication is that if you're seeking to rent an apartment, let's say with your family, and a landlord indicates that they don't accept children in their building, or they otherwise try to deter you from renting because of your children, this could likely be an illegal fair housing violation. The problem is that it's not usually so clear cut that, you know, a denial is I'm not accepting you because you have children. It's more subtle. It's really harder to detect. So you might just sense that something was weird about this interaction. I feel like I'm being deterred from this unit, or steered maybe to another building or another community or whatever it is. So you don't have to have like hard cut evidence that someone's discriminated against you. Even if you have that gut feeling that something went wrong with that housing interaction, you can get help. There are organizations out there that help to investigate the issue to determine if a violation has occurred. And throughout this presentation, we'll be providing resources, I believe, in the chat box, so you can identify organizations that can help you. In Cook County, we have even more protections than the federal level for individuals. And two key areas we wanted to highlight are based on source of income. That's including if you have a housing choice voucher, formerly known as Section 8. And what we're going to talk about today is based on a previous arrest or conviction record.
Great. Thank you, Patricia. So how does Cook County protect people with arrest and conviction records when it comes to housing?
Sure. So we have a law called the Cook County Human Rights Ordinance. This law is very similar to the Fair Housing Act in that it ensures that housing decisions cannot be based on your protected class. In Cook County, we have all the same protections at the federal level, but we also have additional protections, for example, for marital status, parental status, military discharge status, again, source of income, which we talked about, housing status, gender identity, and what is called in the law covered criminal history. And that's basically your arrest or conviction background. In 2020, that new right went into effect to make sure that people with records have equal access to housing. So since 2020, landlords can now not consider an applicant's arrest, charge, or citation, participation in a diversion or deferral of judgment program, any sealed or expunged records, any juvenile records, or any convictions that are older than 3 years old, with a few exceptions for certain sex offenses or certain drug offenses that are tied to federally subsidized housing. But that's kind of a really narrow range of convictions, and a legal service provider can really help you navigate those exceptions to the law. But otherwise, convictions older than 3 years old, housing providers should not be considering when making a housing decision. Landlords can consider conviction records from the last 3 years, but only after giving applicants an opportunity to discuss their record and share more information. And we'll be talking about that a little bit further throughout the presentation.
Maria, how did these protections come about, and why are they important to the fair housing movement?
So 1 in 3 adults in the United States has some type of record. Wow. More than half of the people in prison are parents. They're parents of children. I know this personally. So it's not just numbers and the statistics as far as research, but this is also the narrative because I work personally with people who are directly impacted. And as I said before, I am also as well directly impacted. When landlords are able to deny an entire household from housing because of a past record, it impacts entire families and locks them out of opportunities. Before the Just Housing Amendment went into effect, landlords could deny people housing for records very far back in the past, or even for just arrest alone. People with records would never be able to get back on their feet if they are denied housing. Why? Because housing is a lifeline to all other life opportunities. It is definitely a basic need. Any info, that, so this is just so close to my heart. Like, you all, I have a story that I hope you all don't mind me just telling this story real quick. So I did 13 years in prison, and my son, who I'm really getting a close relationship with my children. I have a daughter and a son, and then I have a new grandbaby, right? And I know you all know how incarceration just affects families, period, and especially when it pertains to housing. My son recently opened up to me and told me, amongst a lot of other things, but this particular thing had to do with housing. He said, I used to imagine that when you got home that we were going to be able to live together, and it was going to be you and me and my sister, and and my children actually witnessed the barriers that I went through. They actually witnessed me having to live out of my truck, basically, and having like all of my personal belongings, social security card, just, women items, personal items, in the trunk of my car. They witnessed me having to basically couch surf. It was so demeaning. I almost violated parole because I was living in a place that wasn't productive or conducive or safe for me, which the the situation basically could have sent me back to prison. There are women and men that I work with on a daily basis, who are subjected to domestic violence, and their children are subjected to many things, and because they have to stay wherever they have to stay at. They have to, they have to survive. So a lot of these situations are not safe. No, it's not healthy, but people don't want to go back to jail. People don't want to go back to prison, and people just want a warm place to stay. Also, when I think about, so I worked in transitional houses too, and a lot of people I know, they would be afraid to relapse, people that had drug addictions, and they would have to live with people who are using drugs, or where people are doing certain things. Like, it's so many things that I can talk about. I could just go on and forever about the stories, but I'm just going to say that a lot of the people that I'm talking about, this is actually how we got this ordinance passed, because of these people actually having the courage enough to share their stories with everyone publicly, with the media, with the Cook County, or with us, with the world, with everybody. They just shared their stories and put themselves out there, which was very vulnerable. Especially, just homelessness is it's a vulnerable topic anyway. We actually had created a video called "We Are Not Our Records," and the video is just narratives of people that was directly impacted by the situations, and the stories were very diverse. However, the common thing was that people's lives were actually in danger, or they were in jeopardy of going back to prison because of this. But because of those people that were directly impacted, like myself, telling our stories, sharing our stories, that was a major part of the passing of the Just Housing initiative. So I just definitely want to say that wherever I go, give a shout out to those people who were courageous enough to tell their stories.
Thank you so much for sharing. Your courage helps to give other people hope. So thank you, Maria, for stepping up and helping to coalesce these groups together, because I know that you are a really strong advocate for this ordinance, the passage of this ordinance. It was very touching for you to share all that with us. And I'm glad you're here. You're here today in this place of power, passing on empowerment to other people. So I just want to thank you for that. I'll let Ellen, if there's some more questions out there, I'll let you pick that up. I just had to say that I'm humbled by your experience and by your courage.
Thank you so much, Aileen. Thank you all.
Amen to that. Thank you, Maria. So what should a tenant expect when applying for an apartment if they have a record right now?
So before I answer that question, I want to piggyback on that, Aileen. You know, if it weren't for Maria, if I could be honest, we would not have these protections in place today. She was truly the backbone of our coalition. So it's just really exciting to be where we're at today after, you know, a 4-year campaign to get these new rights in place. But now under the law, landlords have to consider other aspects of an application before even conducting any kind of a background check. So for example, a landlord might ask an applicant to demonstrate income or credit history or landlord references to determine if you can afford the unit. But the arrest and conviction background check is not a part of that initial, should not be a part of that initial process. So a landlord can still deny an applicant at that phase if they don't meet that initial criteria. But if an applicant successfully meets those initial requirements, a landlord can then run a background check. And it's important to note that landlords are not required to run background checks at all, and some landlords choose not to. But for those who choose to run a background check, they have to be looking at the past 3 years of conviction records. And convictions prior to this time should not be factored into a housing decision. So if a conviction is found within the last 3 years that the landlord finds to be potential grounds for a denial, the landlord must provide the applicant with a copy of the record and an opportunity to provide evidence to dispute the accuracy or relevance of the record that they found. It's important to note that the applicant must respond within 5 days to what's called this individualized assessment. And during this individualized assessment, the landlord can consider factors like the nature and severity of the conviction, the number of convictions within that time frame, how much time has passed since the last conviction, the age of the person at the time of the conviction, and this is important, any evidence of rehabilitation since the conviction occurred, their tenant history or their history as a renter before and after the convictions, and they really have to consider whether or not the conviction was related to a disability. And if you have a disability, a reasonable accommodation could be provided. And again, that's an area that you should and can seek legal assistance to help navigate. So once an individualized assessment is complete, the landlord can accept or deny an applicant. And if the landlord denies due to, the findings of the record and the individualized assessment that takes place, they must explain why that denial was necessary to protect against personal safety or property of others. And they have to inform the applicant that they have the right to file a complaint with the Cook County Commission on Human Rights if the applicant feels that throughout this process, their rights were violated in some way.
Can I just ask a quick question, Alan? Trish, do you think that that communication needs to be in writing? Is there a way that a tenant would be aware that they received that notification?
Yes, it has to be a written notification, and it has to be like the background check has to be provided as well. Because one thing, especially with the individualized assessment phase of it, there's so many errors that come up in a background check. I mean, there's a lot that's just like factually wrong. Like we've heard so many stories of people who like it's not even the right name, or it's not the right birthday, or like just things that go wrong. So it's really critical that you understand like what information is being used through this process, what information is out there, about your background. And then for the denial, the landlord has to be specific in explaining how that past record is tied to, how they think the person will perform as a tenant. It can't just be, well, I don't like this type of conviction or something like that. It can't be arbitrary, basically. And yes, all that has to be provided in writing.
And perhaps a related question, what does it mean to dispute the accuracy or relevance of a record? And Maria, maybe that's a question you can take.
Sure. An applicant can dispute the accuracy of a record by showing proof that there is an error on the background check. An applicant can also dispute the relevancy of a record by showing evidence that the background check does not show who they really are today or how they have changed since the conviction. For example, by showing evidence of rehabilitation, court issue good conduct certificates, employer recommendations, educational vocational training, participating in programs that assist with the transition back to the community. And that also includes, I always like to emphasize when it comes to people directly impacted, that volunteer work definitely plays a role to me. I use a lot of volunteer references myself. Letters of recommendation from community organizations, counselors or case managers, teachers, faith leaders, or parole or probation officer. I just want to say too that this is also an incentive, I feel, me personally, because in the prisons, it's like a narrative in the prisons that it doesn't matter what education you receive in the prison. It doesn't matter how hard you work. It doesn't matter about classes or anything, because it's not transferable and it's not going to be respected in society. So this is also, I think, important when we go to the prisons or the jails and we talk about the implementation of this ordinance also. So this means that it is important to know what is on your record before searching for housing. It is, as Patricia stated, it also is important that you clear up your record through sealing or expungement, which has definitely been helping a lot of people. Many records in Illinois are eligible for sealing or expungement, and you can seek this legal assistance to determine which of your records can be removed from your background, or background check. So yeah, and I also wanted, if you all didn't mind, I just wanted to say one more thing about my personal, my personal story. Just one small thing that's really big. That I have had my own apartment. I have been renting out now for almost 5 years, and my landlord, she states consistently that she feels that I am the best tenant that she has. And actually recently, once again, about a month ago, she called me to say, I hope you're not leaving, because you're the best tenant that I have. I have no problems with you and this and that. And then my man, I'm just like, I need the world to hear this, like, but I just wanted to share that as, personally. So, the
That's so
stereotype.
awesome. That's so awesome. We need more landlords like yours and tenants for landlords like you. That's awesome. So what should someone do if they believe their rights have been violated or a landlord doesn't follow the correct process?
Well, Alan, thank you for asking that, because we've posted a list of resources that tenants can use to file complaints. They can file a complaint on their own with the Cook County Commission on Human Rights. And it's filling out a document, and they can present their story to the commission and get help that way, possibly even get housed, because that is one of the things that the commission can do. If it's been shown that the housing provider has misapplied or did not apply this ordinance properly, they can get housing. So that's important. They can also get legal assistance, and those legal fees can be paid if the housing provider is found to have violated this ordinance. So and we have a list of several organizations that help enforce this ordinance, including the Lawyers Committee for Better Housing. So if you know someone or love someone who may have been impacted by having their housing restricted or these barriers in place, you can always call us as Alan mentioned earlier in the evening, 312-347-7600. And to see if there is some help for you out there. There are multiple agencies, and we'll be posting that today.
Thank you, Aileen. And those numbers have been posted in the chat. Is there a number, should folks call CAFA? Is there a number that you guys would like to share, Maria, as well?
Yes. So my email is mmoon@kafa.net. Wait, I need to put it in the chat. And CAFA is CAFHT. Hello. I have to put it in the chat for you all.
Oh, that'll be great. And people can reach out to you, Maria?
Yes, they can reach out to me, or they can reach out to Patricia or Gianna or Sarah or any of us. Yeah, so I'll definitely put that in the chat. We actually have been getting a lot of referrals, and as far as individuals who are directly impacted. So that's been being on quarantine has not been a hindrance to us connecting with people.
That's wonderful.
Not at all. No.
Well, one thing I want to mention to the viewers, if you are applying for housing, one thing we would ask as an enforcement agency is to try to document the best you can your application process. So when you're filling out an application, try to get a copy of that application that you've submitted. And if you're submitting it by email, all the better, because you're saving a record of submitting that. The same with the communication that you hear back from the prospective housing provider. Try to save that information for yourself and create a file so that you have records of where you've applied, how that process went. And if you start to see a similar pattern, if you feel that you are improperly being denied housing, you'll have a lot of documentation you can present to, if you're going to file a complaint on your own with the Cook County Commission, that will be very helpful for them to evaluate your claim. And the same with a legal services organization as well. So do keep good records. It will help. Even if you're doing it on your phone, screenshot those applications, screenshot those communications that you may be getting back online on some online portal. So that would just be a tip that I would like to mention to everyone.
Thank you, Aileen. I think we've reached the end of our questions. Maria or Patricia, do either of you have any final words of advice for tenants who might be watching this, or other important things to know about this particular amendment?
I would like to give some encouraging words, which is my favorite thing to do, if you all don't mind. So I just want to say that if anybody is going through anything like this, as far as housing barriers or discrimination or stigmas, hold on. You know, there is hope. Like this is one of the ways, the manifestations of hope, this ordinance being passed. And for those who may feel excluded and feel hopeless because maybe maybe your conviction is not sealable yet, right? Or maybe it's something going on with your credit or other things that's happening, to hold on, because I've been so down, you know, but in a midst, I was able to have hope, and like things turn around. They turn around. So no matter what's going on externally, no matter the policies, the stigmas, whatever, like you can overcome any glass ceilings or anything. So hope. The word for today is hope.
Thank you, Maria. That was inspiring.
I needed to hear that myself today. So yeah, there's nothing else I can say, but just thank you for having us here.
Thank you both very much for your stories and your inspiration and your advocacy. We need you, Kappa. Thank you.
Yes, we do. Thank you both again so much, and thank you to our viewers for watching tonight. And please do reach out to LCBH or to Maria and Patricia at CAFA for help with any fair housing related issues. And with that, we will conclude tonight's Tenant Thursdays, and we hope to see you all here again for the next episode.